The following is a tape transcription of the bankruptcy proceedings of Vincent Cusano, also known as Vinnie Vincent. His first tape is from April 11th, 1989. The bankruptcy proceedings were in federal bankruptcy court in the city of Los Angeles, and the government official presiding, the federal bankruptcy trustee, is Mr. Alvin Marr.
Good afternoon. Today's date is April 18th, 1989. The time is approximately 3:22 p.m. My name is Alvin Marr. I represent the Office of the United States Trustee for the Central District of California. This is the first meeting of creditors and examination of debtors pursuant to Section 341A of the Bankruptcy Code. The case name before us is Vincent J. Cusano. The case number is LA 89-04620-CA. The petition was filed on March 7, 1989. Today's meeting is being recorded by a tape recording machine. The tape will be held at the Office of the United States Trustee for 90 days. At this time, would the debtor please stand to be sworn in? Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth and nothing but the truth, so help you God? Yes, I do. Thank you very much. Please be seated. Would the debtor please state his appearance for the record?
Say what?
His name for the record. Mr. Cusano, are you known by any other name? Would debtor's counsel please state their appearance for the record?
Simon Aaron and Lisa Vatan of Manette, Phelps, Rosenberg, and Phillips on behalf of the debtor.
I understand there are members of the public in this hearing and would ask that they identify themselves for the record.
How do you spell that?
T-I-O-P-R-O-W-S-K-I. Mr. Simon, Mr. Aaron, excuse me. Will you give me a brief description of the filing of the bankruptcy, why it was filed, and the debtor's plans for reorganization?
Okay, before we do so, Mr. Moore, I'm going to object to the presence of the two members of the public you mentioned to this proceeding. They are not creditors nor parties in interest in this case. They're here. Their purpose here is solely as a media, for purposes of media. And in fact, we had requested that they allow us to conduct the 341 in private as a matter of the debtor's personal bankruptcy. You, on the other hand, went out of your way to invite them back into these proceedings and disrupt the administration of this case, not only for your office, but for the debtor and for the administration of the Chapter 11 in the plan. We think it's questionable in terms of your conduct. No, they were not at any time threatened. They were asked politely to leave because they aren't creditors and aren't parties in interest. As you accurately advised us, these matters are a matter of public record. The record in this case is on a tape, and I advised them particularly they could have the tape, they could have access to the tape, and access to all court-filed documents. There are matters there are matters here that are not part of court-filed documents, they're not matters of public record, they are matters uniquely of interest to the Chapter 11 case and the success of the Chapter 11 plan. To suggest that this is a matter of public interest in which people who have no interest in the case, solely media, we think is disruptive, not only to this proceeding, but also to the formation of the debtor's plan and the proposal and a candid discussion with the U.S. trustee.
And we think that you know that, Mr. Aaron.
We would again request that Mr. Petrosky? Thank you. And Mr. Starr excuse themselves so we can go ahead and have our candid discussion where we can discuss the terms of the plan and how we see this case proceeding. If that is not what you have in mind, we are not going to make those matters of public record so that they can be reproduced somewhere.
The comments are duly noted, Mr. Aaron. Let me ask again, Mr. Aaron, the description of this bankruptcy.
Okay, we would ask that will the members of the public please excuse themselves?
Okay, fine.
Thank you, gentlemen. I appreciate it. Again, I will give you.
The time now is 3:25 p.m.
Yeah, for the record, I have given both gentlemen my card and asked them if they have inquiries, they can certainly contact me, and I will make all public documents available to them.
I understand, Mr. Aaron. The time now is 3:25 p.m. This matter will be reconvened in a few minutes. Thank you very much. The time now is 3:30 p.m. Mr. Aaron, will you give a brief description of the nature of the bankruptcy, why the bankruptcy was filed, and the debtor's plan for reorganization?
Certainly. The bankruptcy was essentially filed for two similar reasons. One was in connection with a piece of litigation involving Hirsch Gardner, which was being conducted in Massachusetts, in the state court in Massachusetts. The litigation had been settled, or a settlement agreement had been entered into, which was breached by Mr. Gardner and his counsel, Mr. Carducci, at the time of a hearing, at which time they attempted to proceed with a hearing on a judgment in an amount substantially in excess of the settlement amount. The settlement was entered into not because of the merits, but to avoid litigating in Massachusetts and to avoid further repercussions, one of which was the filing in this case. In Massachusetts, apparently the court did not understand or did not wish to confirm the settlement, instead entered a judgment which is not yet final. The petition was filed for that reason, as well as another matter which was being arbitrated in New York, and I don't remember the gentleman's name, George Suet, who was the claimant in New York, and it was a matter of arbitration under which Mr. Suet claimed he was owed $150,000 or more. So, again, both of these individuals, Mr. Gardner and Mr. Suet in particular is a former manager of Mr. Vincent in his recording career. Mr. Gardner, on the other hand, was a former associate who at one point had auditioned for Mr. Cusano as a drummer, with the idea that he would become part of Mr. Cusano's band. Mr. Cusano did not appreciate Mr. Gardner's form of music, and Mr. Gardner was dismissed. Mr. Gardner sued on the theory that he had a contract.
The time is approximately 3:35 p.m. Will you continue, Mr. Aaron?
Yes. As I was saying, Mr. Gardner was dismissed. He then sued Mr. Cusano under the theory that there was an oral contract under which they were going to produce things together, that he was a producer, an orchestrator, choreographer, God only knows what else. And therefore, he was entitled to damages against Mr. Cusano for certain songs that they purportedly had authored. Again, as with all litigation, especially litigation based on an oral contract, the debtor's position is that Mr. Gardner isn't owed a dime, and he is a claimant who has cross claims filed against him, and that ultimately will have to be resolved in connection with litigation on an objection to claim. Mr. Suet, on the other hand, is a claimant as far as we know. The arbitration never went forward because the bankruptcy was filed the day before. And that may end up having to be resolved either in the context of a litigation over a claim or in the plan itself. The case itself revolves around Mr. Cusano's services as a performer and as a songwriter. Those services are post-petition services. Mr. Cusano's plan contemplates the use of post-petition earnings to fund a plan through which he will provide creditors with the value, the liquidation value, if you will, of his assets, and thus retain his residence or the small equity that remains in his residence. Mr. Cusano has a wife and a child, and people do not like to. 2 children. noted for the record, 2 children, not child. And as with any other parent and head of household, one does not like to lose one's home. We contemplate filing a claims bar date within the next couple of days.
And what date have you selected?
We have decided we would like to see the claims bar date set about probably about May 25th to June 1st. That would be our optimum. Whether Judge Ashland would go along with that, I don't know. My inclination is he'll go along with the June 1st bar date, assuming we file our application and it's approved and there's at least 30 days notice, which there would be. We anticipate that a disclosure statement will be prepared. We'll start preparing the disclosure statement. Disclosure statement should be filed within, I would think, within 90 days, if not sooner. The plan basically will provide for funding into a pot for unsecured creditors. Secured creditors' interest will remain unaffected by the plan, thus unimpaired. Unsecured creditors will be impaired because we don't think that even the allowed claims are probably in excess of the assets that are available. So that we anticipate there being an impaired class or class or 2 of unsecured creditors, and the pot being distributed to those unsecured creditors on a pro rata basis. The assets would include, we believe, about $30,000 to $40,000 worth of equity. Well, it's not. That's actually probably about $30,000 of equity. I think with the homestead it would be about that range, plus whatever the value of the royalty stream of the debtor's prior compositions would be. And as we discussed over the phone yesterday, that may be a very difficult number to ascertain. We believe they have no value because of the way that you have to compute, because of the way that the business works is that the royalties from songs, from albums, from other from other publishing would have to first go to recoup the record company which produced all of that material, and then be available, and at that point would be available as royalties from future sales. For example, I think we used the example of I think the last record sold about 150,000, and Chrysalis is unrecouped about probably about $800,000. I don't know if you heard that.
How much?
About $800,000. So that if we assume that a royalty from an album would be $1, Mr. Cusano's royalties per album would be $1. It would be 800,000 albums that would have to be sold, and this album has already sold 150. We will produce at the time of confirmation. Of course, we'd have to put on evidence as to what the present value would be, but we think more than likely that's going to be a very nominal figure at best. And essentially, it's a pot plan. It's not complicated. Should be very straightforward. The only contingencies will be the litigation of claims. One claim, the Hirsch-Gardner claim, in fact, has a $24,000 bond, or a security deposit, if you will, that was resulted from a writ of attachment about 2 years ago or 3 years ago. So that conceivably would be the only other asset, would be if we were successful on objecting to the claim and the claim was disallowed in its entirety. That $24,000 would come back into the estate and be available for other creditors.
must assume that at least $30,000 will be in the Senate reorganization due to debt.
I think that's a safe estimate. We anticipate that if we can proceed fairly unencumbered by other problems, that administrative expenses, including the trustee's minimum $150 fee, should be somewhere in the $10,000 to $15,000 range, worst case. Right now, we've probably got substantially less than that in the case. And like I said, with a little bit of luck, if we're not having to come back and repeat 341As and go into court on more than one occasion on just the necessary motions, disclosure statement, confirmation hearing, there's no reason that the plan as proposed should involve a tremendous amount of administrative expense. Which also brings me to the status of our application to be employed as counsel.
It's up for the judge, I'm sure.
Oh, it's already been forwarded on?
I believe so. It's, I know that there's a lot of time delay in terms of setting up applications for the judge's time.
Yeah.
I'll check on that.
I would appreciate it so we know the status, because we don't want to face ourselves with the problem of having done a lot of work and then having to explain why the order didn't get entered for some time.
I understand.
Anyway, I think that answered the three questions you posed.
Yes. Let me ask the debtor, how much money do you have in the bank account right now?
No. Oh, I'm sorry. $20.
Please get closer to the mic. I mean, I can do it here.
Yeah, $20.
How many accounts have you opened?
I tried to open a debtor in possession account,
But how many debtor in possession accounts have you opened?
I opened one general account, but it's not open because it needs a $100 deposit to open it, and I don't have $100.
The application is in, and we submitted a copy of it to you, Alvin.
Right.
You have a copy of the application to open an account with a signature card. Which is, Alan, this may be a good time to talk about the application to borrow funds.
Yes, I understand there's a motion. I came to notice of it by accident because, on a Thursday credit conference, pack was found outside our door in this hallway regarding a ex parte hearing for a $18,000 secured loan. It was not signed. I mean, it's just as if somebody dropped it there. So he explained that $18,000.
Sure. The debtor testified he basically has no money. He has a project that he is putting together for the purposes of entering into a new recording agreement with the hopes of entering into a new recording agreement. The project will take some funds. The bulk of the funds are to make sure that the debtor maintains current on his living expenses, maintains current state of the mortgage on the real property, and pays other living expenses in order to allow him to continue in his livelihood and thus be able to generate future income from which to fund the plan.
So when's this ex parte hearing planned?
Thursday at 9 o'clock before Judge Ashland.
Alvin, just in case you did not receive a copy, I made sure that our secretary sent an additional one. You had mentioned that to me the other day.
Yes, I just was amazed to just find out in the hall.
Maybe the messenger just dropped off there after it was
Actually, I
closed.
believe that he serves them through all of them, unless they weren't in the in-house copy. Anyway, the application again is set for Thursday.
Okay.
We believe the funds are necessary. It's not going to impair the plan or the equity of creditors, because if the payments aren't made, the first mortgage is going to exceed the $18,000 because there's going to be default and there's going to be no payment of interest. it's sort of chicken and egg, if you will. You can not make the payments and not borrow the money, but the first mortgage is going to go up anyway, so that there's going to be less equity for the benefit of unsecured. You can make the payments and actually save a little bit of equity.
I understand. The residence that you have, Mr. Casano, can you tell me the location?
7538 Bovey Avenue, Cedar, California.
Do you have any interest in other real estate in the United States?
No, I don't.
What's the value of your home?
Appraised value is $240,000.
And how was the vehicle made, or when was it made?
October, November of last year.
November of '88? And how much equity do you have in the house right now?
Including homestead?
Yes, including homestead.
I think that, well, assuming we have the funds when we make the payments, because we have a payment due this month, the mortgage is there's about $175,000 owed against it.
Is that true, Mr. Casano, $175,000?
I think so. I'm really not sure.
That's in the ballpark. It's 170 to 175, I believe, Alvin, is what this mortgage is. If you add the homestead to that, you're talking about an excess of about $20,000 to $20,000 or so. $45,000 homestead, $240,000, and let's say one set for round numbers, 170 and 45 is about $215,000. So it's about $25,000 or $30,000 of equity above the homestead.
Okay. It was mentioned that you have a trustee against your property. Who owns the trustee?
What's the trustee? I don't know.
It's the mortgage. Mr. Casano is an Easterner. They don't know about Cal trustees.
Delaware State.
Yeah.
And what's the monthly mortgage payment?
Somewhere close to $1,500.
Are there any delinquencies pre-petition on the property?
Not that I know.
Alvin, you may want to, I don't know, again, property tax gets paid semi-annually, so I don't know if the payment has been made.
Property tax?
Yeah, I know. That's why I said it. I mean, I happen to know that they pay property tax twice a year. I don't think the payment is due yet. But again, it's going to be due, and unless we have the money, it's not going to be paid, so that I guess you can look at it as, I mean, you could prorate it, I suppose, which is what you do if there was a sale. They prorate the tax.
Is the property insured, Mr. Casano?
Yeah.
Yeah, you've been provided with copies of the binders and policies, I believe. Evidence of insurance has been provided to you with the package that we delivered yesterday.
But it is insured by Mr. Casano. Are there any automobiles in this estate?
No.
Are there any leased vehicles in the estate?
Yes.
And what's that leased vehicle?
It's a Mercedes 629.
Now, what year?
78 or 9.
And what's the lease payment on the vehicle?
180, 200, somewhere in there.
By reviewing your schedules and statements of affairs that you sold a car to your father-in-law, Kenneth Peters, for $18,000. What car was that, and when did you sell it?
That was the Mercedes.
But when $2,000 and all.
Partial of that was to pay the attorney fees involved in getting this and living expenses. Yes, there was also $10,000 that was put back into an IRA fund that I had.
Whose IRA fund is that?
Where is the Great Western?
So you understand, Mr. Lohr, there was a loan against that IRA account to pay for living expenses pre-petition. The funds were put back into the IRA for two reasons. First of all, the debtor has the right to exempt those funds as a matter of Section 7.1.14. Okay, the Cook Code. So he basically took it and turned it into an exempt asset. The other reason was that if the fund is not repaid, there is a penalty, a tax penalty, that is, there's a penalty, I think it's more, I want to say 10%, but it is more than, I think it's more than 10%. So that if the funds were not repaid within a period of time, there's a penalty. The claim, I guess, if you will, a tax liability is not only the withdrawal of the funds, but a penalty on top of those funds.
What's your monthly living expenses, Mr. Castano?
Close to $6,000 a month.
I was reviewing your schedule, and you make liberal use of the terms unknown, contingent, and disputed. Can you state the reason why?
You understand the question?
Okay, can I take a shot at it?
Give me a copy of the schedule.
I have the petition.
I'll lend you my account, sir.
Thank you. Mr. Santa, what Mr. Moore is talking about is the list of schedule, and he has opened it to A3. But you'll see on Schedule A3, creditors' unsecured claims. For example, you have my law firm. There's a claim and it says unknown. Siegel and Feldstein, you have a claim of $2,500, but you list that as disputed. Certain other claims, Carvin, a contingent and disputed, and it's also unknown. I think the question is,
Why the liberal use of those terms and the amount, especially unknown?
well, to the extent that you're asking him for, I mean, again, disputed and contingent claims are a matter of law. They're either disputed or they're not. So if you want to ask him if you want to ask me, I'll be happy to explain. I think you're asking him for a legal conclusion.
No, the nature of those debts. What is the nature of those debts? Counselor, if you review it, part of the requirements is that you describe the nature of the indebtedness.
I'm not arguing with you, Alvin. What I'm saying is if you're asking him to describe disputed and contingent, no, that's different. If you're saying that what are the nature of the debts that are listed as unknown, and the answer is we've listed a lot of debts. We've listed a lot of debts as unknown.
And
The reason for that,
schedules are incomplete because I do not know the nature of the unsecured debts you've listed. You've listed it as contingent disputed, but you don't tell me how they arose and why you're claiming.
Most likely, you probably won't hear from any of them.
So that doesn't answer the question.
I guess the answer to the question is we're not sure that we don't believe they are creditors. We have listed them as out of an overabundance of caution, as we're allowed to do, to make sure that everyone who has a claim, as that is defined in the bankruptcy code, which is very broad, has notice of this bankruptcy. The key word here is notice. These people all have notice, and we don't believe they are creditors. They may file claims and show us that they are.
But about the firm that's representing you now, you put down unknown as the amount. They don't even cite the credit relationship to the firm that's representing you today.
You want to tell them that Peter Paterno represented?
Well, Peter Paterno is my attorney also from that firm, and I'm not sure of my outstanding bill with him. I don't know what it is.
So that's legal fee.
Legal fee.
I noticed that there are several in which there are no disputed or contingent amounts, but there's still no definition of terms of how the claim was incurred, such as Brockton and Dunlap Pitt. And George Stewart.
Well, George Stewart is listed as contingent and disputed in the amount of $60,000.
Yes, except that there's no description of why the $60,000 rose, although I have some idea of how that rose based on the description.
Alan, maybe we can alleviate your problem simply. I guess what you want is a description as to each one as to how the debt was incurred.
Yes, of those that have amounts.
Why don't we just supplement this for you? We can file an amended one.
That's why I was going to ask that we get.
That's fine. I mean, we could save ourselves the trouble of going through this on an item by item basis. Yeah, that's easy enough to run. You understand what we have to do? Let's go through it.
You have listed under musical equipment as part of your assets. Guitar, is that tangible personal property of any other description item in Schedule B2? Guitars, is that one guitar or is it multiple guitars?
There's more than one guitar.
How many?
5 or 6, maybe 7.
And how did you come to the valuation of $2,500?
Well, they were lent to me. Mainly there's an endorsement, and a company or different companies lends me the guitar on a long-term basis, and that's about the going rate per guitar.
So it's $2,500 per guitar or $2,500 for all 6 or 7 guitars?
All 6 or 7 guitars.
And basically what we did is we looked at it, we asked Mr. Cusano to go to a guitar shop and say, if you wanted to buy this, what would you buy it for? And, there's not even with his autograph on it, I don't think we're going to get much for...
No, you can't. They really are not good for resale. They have no real resale value.
Even with an autograph.
They really don't.
With the item N, songwrite, the valuation, the market value is unknown. There's a number of categories which you listed. Songs on the Bangles album.
That's one song. That's the song. It's A Play for Her Now. That's just
Make a Play for Her Now.
No, it's actually Make a Play for Her Now, and it's one song.
One song.
Okay. How about on the Chrysalis?
There were 2 albums, about 20 songs.
Okay, on Chrysalis there were about 20. There were 2 albums, about 20 songs. Were they all written by you? Okay. And then should we go to 3?
Yes, please.
Okay, when you were with Kiss?
11 songs.
11 songs with Kiss.
And Counselor, will you, for the record, may I ask your client, debtor, to state what are songwrites? Do you know what songwrites are, Mr. Castano?
Basically, yes, they're publishing and songwriting, and depends. It's kind of complicated. It's the income you derive proportionate to what you write on a song. If I'm a partial writer and there's 3 other writers, I receive a quarter of the value of the song. If I write the whole song, I receive the whole song. Apparently, a song is worth about 4 cents if you write the whole song.
I beg your pardon?
It's worth about 4 cents if you write the whole song.
Is that on a per sale? You say that's the royalty.
Yeah, that's what you get when you sell that.
Again, we were talking about if your royalty was $1 per, it's actually, if you write the whole song, it's about 4 cents.
Or about 4 cents.
About 4 cents an album.
If I'm one of 4 writers, I'm worth a penny.
The song is worth a
The
penny.
song's worth a penny.
Are you getting any royalty rights or royalty payments under any of those items, such as Make a Play for Her Now, the 2 albums, 20 songs, and a Christmas
No.
records, or the number of songs that's just?
No.
Now, but just so you understand, that Christmas albums are substantially unrecouped, and that they have to be recouped before the royalties would start accruing to Mr. Cusano.
Which brings me to the Christmas contract, Mr. Cusano. Am I to understand that during your relationship with Christmas, you made 2 albums?
Mm-hmm. Yeah.
And those 2 albums have 20 songs apiece?
No, 10 songs apiece.
When were you on contract with Christmas Records? What year?
From 1986 to 87? Or 88? September of 88.
1 year.
1 year.
1 year ago.
Mm-hmm.
86 to 88. Normally in these contract albums, so you understand, they usually require certain albums to be presented by the artist on a time basis, whether it's like one album a year, or usually 6 months after your last album.
Right.
So you have to make 1 album a year. You could make more, but you have to at least make 1 album a year. And the contracts usually are for terms. For example, a contract could be 5 years. It'll be for 5 years and 5 albums.
As a contract terms of Christmas Records, was it a 2-year contract?
Well, it was per album contract.
So it was 2 albums.
It was 2 albums. You know, it's basically that.
And what were the contract terms in terms of advances? I assume there were advances to you as a per album basis. That's true or not?
Pardon me?
On a per album basis.
Yes.
Okay, what would the advance paid to you for those 2 albums separately?
100,000 each record.
Now, you mentioned that during the careers conference about the advances. What are the advances for, and what business do you make from those advances? Are they to you individually, or what's the use of those advances when you get them?
They're to me personally, but I also have to run my business and pay attorney's fees. You know, I mean, it's...
Don't understand.
I mean, this is...
You're getting the answer, I think. He wants to know, when you get the advance, do you also have to pay costs associated with the production of the album?
No. The album production is paid as another advance, which... In other words, I get an artist advance and a songwriting advance. And they give me another advance to make the record. And the record costs approximately $200,000 to make.
Okay, so let me understand this. For the first album, they advanced you $100,000. To produce that album, they advanced another $200,000. That $200,000 goes to recoup the cost of producing that album.
Right.
So that $100,000 goes directly to you as an artist advance?
Yes, but it's also recouped. I mean, I have to recoup that too. That's not free and clear. In other words, it's basically if I gave you $100,000 to do a job, and you have to produce to me $100,000 before you get any more money, you know, of your value.
Look at it as a draw against commission. So that's more of what it's like, really. Isn't it? Yeah. I mean, it really is. Like, thing happens with partners in law firms.
I understand, Counselor. The $100,000 on your initial album and the subsequent $100,000 on your second album, do you have an accounting of where all the funds went?
Absolutely.
Yeah. And by the way, do you keep your own books and records that's stated in your statement of affairs?
I do now. My wife does. But, I mean, they're in my possession now.
I noticed there were a number of individuals that had access to your books and records. Park Palmer, Traeger, and Fenton, and
Siegel and Feldstein.
Well, Parks Palmer were doing... It was something I did not want to get into, which was forced into me by a former manager named George Stewart. They were an accounting firm. I initially only wanted them to do accounting for a tour, which was coming up, but instead I got railroaded into having them do accounting for me, which wasn't needed, which was on a personal home basis, which I've always paid my bills, or my wife has, and I didn't need an outside accounting firm to write my monthly checks, which are all the same month after month, year after year. So this firm had my personal accounting for approximately 18 months, 18, 20 months, something like that. And then at that point, I took over my own books, and I've been keeping them ever since. Prager and Fenton had done my taxes. They had not done my personal books. Siegel Feldstein was an accounting firm that came in to do a tour as of last summer, and they were dismissed by a former manager that I had at the time, and not through me. But I keep my own books are now. I keep my own books.
Who's Nigel Thomas, a chair of Access Worldwide Limited? Is that as one of the people who have possession of books and records? Well, I think
None.
Isn't Nigel Thomas a former manager?
He's a former manager, but he doesn't have my former records. Is that what you're saying?
I thought he had some because he hadn't paid some.
He had tour records, but he doesn't have my own personal.
I think you need to understand. Yeah, we're talking apples, oranges, and pears. We have Mr. Cusano's personal books and records and personal affairs. We have Mr. Cusano's business affairs. Among Mr. Cusano's business affairs are things like tours. Tours are accounted for separately, so Nigel may have books and records relating to a tour. Siegel and Feldstein had access to books and records relating to a tour. But so it's Siegel, I guess it's hard to explain other than there is difference. A tour is almost like look at it as a separate business venture for which separate books are kept. Is that making sense, Al?
yes, it does.
Okay. As opposed to Mr. Cusano's personal books and records, which he keeps, Mr. Thomas, Siegel and Feldstein, Parks Palmer, Prager and Fenton have all had access to books and records at a time, some for a particular purpose, that being a particular tour, or more than one tour.
Okay. But you have in your possession your personal records of all your accounts.
Yes, I do.
And you can reconstruct your transaction.
Yes, I can.
By the way, have you had any of your books and records audited before?
No, I haven't.
And have you filed your income tax return for the prior 2 years?
Yes.
87, 88?
87. Or 88. Just in 87.
87, 88 have both been done.
Yeah.
Yes,
I just did it.
Did you consider it just?
Good. I
Just made it.
statement of affairs that you also get interest income. And that's item 5, but you don't know if it's substantial or not. Is it substantial interest income that you obtain from your particular deposits and safe deposit boxes and financial accounts?
I don't have any safe deposit balances.
Deposit boxes and financial accounts?
I don't have any safe deposit balances. Approximately. Substantial interest. Approximately. Substantial is. I can't even think. I mean.
It was a money market account.
Yeah, but for 6 months.
Right.
$1,000, $2,000.
The vast number of accounts you've had in the last 2 years, I've counted roughly about 8 to 10 accounts, which is listed as Exhibit 1. You have one cash management account and several bank accounts, several CDs, a money market. And Great American First, there's listed 3 accounts in which the debtor, you have authority to make withdrawals and I guess deposits. You still have the book of records for those accounts?
Yes.
Have those accounts, are they opened right now or are they closed?
Alvin, just so you know, one of the declarations that we submitted to you goes through this in detail about which are open and which are closed and the dates that they were closed.
Okay. But I'm asking,
If Merrill Lynch is closed, it's been closed for months. Great Western Savings Bank was a secured loan, secured business loan that I had taken out. I wanted to borrow $5,000, but in order to borrow $5,000, I had to put up $5,000. It was a secured loan, so it was a wash. But that loan was paid off about 3 or 4 months ago. Olympic National Bank and Union Bank were 2 accounts that Parks Palmer, my previous accountant, had opened for me back in '86 and basically '86, early '87. Olympic was an account that they had written my personal checks out of. Union Bank was a business account that they were writing checks from for my business, and those have been long since closed. They're probably a year they've been closed. Bank of America is open now with myself and my wife's name. It's got about $20 in it. And Great American First are my retirement accounts.
And the CDs that you have in Builder Savings that matured on...
Oh, they're gone. They're long gone.
It's matured in November of '88.
That was the one.
Right.
And that, what was the funds from that CD?
The what?
What were the funds from that CD?
What were the funds?
Yeah. How much matured?
I don't know what you mean matured.
I mean,
How much did you take out of there?
I took out of there what I put in there, which was about $25,000.
and what was that used for?
Bought a car.
Was that the Mercedes? The money market account that was closed on 3/8 of '89 at Builder Savings and Loan.
Oh, that was a remainder. There was a $500 amount left that I had never taken out of that one of those accounts, one of those money market accounts. So I just closed the account.
Okay, and where did that money go?
$500. That went to wherever it goes, living expenses. Mainly, it's all been going towards living.
So you didn't end up
It went into the entirety of the funds that you had prior to petition.
Probably went into my Bank of America account, where I write off my home bills.
Yeah. So not used to open a debtor in possession account.
A what?
A debtor in possession
It
account.
was likely used prior to the filing of the case, Al, to pay living expenses.
Okay. So when you closed, there was a zero balance in the account. That's correct, Mr. Casano? When you closed the money market fund,
There was nothing left.
was there anything left?
No. Completely zero.
know the one out of Massachusetts, but this new one, Cusano versus Grayson. What is that about?
Oh, I was involved in an auto accident 2 years ago, myself and my wife, and I'm suing that party.
Have you had any interest in the past in establishing any publishing businesses or corporations that may have existed 2 years ago or exist now?
There is a corporation that Mr. Cusano that exists prior and exists today. It was not listed on the schedule. The schedule needs to be amended to reflect that Mr. Cusano owns 100% of a company called Vinnie Vincent Productions. Essentially what that is a loan-out corporation. Much like a professional corporation for an attorney. Okay, it's very common in the industry for a performer to have his own personal corporation that contracts, and that he is an employee of the corporation. And that way his business expenses are deducted through the corporation.
And is that the only use of the corporation, Mr. Cusano? Is there any value to the corporation?
He's sitting, whatever value you see out is sitting before you today. So you're aware, it has no assets other than, its shareholder and sole officer and sole employee.
As we agreed on prior to today's meeting, Counselor, because I received the compliance and later have yet to review it, the meeting will be reconvened next Tuesday.
Hopefully it won't take us long.
Won't take us long. This meeting was going to be adjourned in a few minutes. I understand. Are you creditors of the estate? Are you creditors of the estate, but Mr. Cusano owe you money? Both of you? Okay. Do you have any questions of the debtor? The meeting was held and it's close to being adjourned. I will note that the meeting is going to reconvene based on the late filing of some compliance items previously agreed on next Tuesday. Do you have any questions?
Can we get their names for the record?
Thank you.
Their names for the record?
Yes. If you beg the indulgence of counsel, would you state your names for the record?
Ms. King, you're a creditor? The nature of your claim? Okay.
Rick Fox, R-I-K-F-O-N.
And what was the first name? I'm sorry?
Rick.
And you're also a creditor?
My name is on there.
Well,
It was undetermined as to what amount we paid.
He's a listed creditor. The lady behind... What's that?
okay.
Do you have any questions of the debtor? Otherwise, I would like to adjourn the meeting until we reconvene. Okay. This matter is adjourned until Tuesday, April 25th at, I believe, 3:15, Councilor.
I think that's what was agreed to.
Okay, thanks very much. Good afternoon. Today's date is April 25th, 1989. The time is approximately 3:22 p.m. My name is Alvin Moore. I represent the Office of the U.S. Trustee for the Central District of California. Seated to my right is Mr. Casey Chen, Senior Bankruptcy Analyst for this district. This is a continued hearing, 341 341A hearing and examination of debtors pursuant to Section 341A. The original hearing was held on April 18, 1989 at 9:30 a.m. Excuse me.
At 1:30.
3:15 p.m. on April 18, 1989. The case name is Vincent J. Cusano. The case number is LA 89-04620-CA. The petition was filed on March 7, 1989. Today's meeting is being recorded by tape recording machine for 90 days. At this time, the debtor please stand to be sworn in. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth and nothing but the truth, so help you God? Thanks very much. Please be seated. Would the debtor please state his appearance for the record?
State the appearance. Your name? Vincent Cusano. Simon Aaron of Manette, Phelps, Rothenberg, and Phillips on behalf of the debtor.
Mr. Aaron, will you give us
If we could have the other people who are in the audience identify themselves and state whether they're creditors in this case or merely interested parties.
Good, the debtor, would the members of the audience please state their appearance for the record?
Charmaine King.
Dan Starr.
Georgia Thompson.
Rick Fox. Georgia, what was your last name?
A-H-A-T-V-I-S.
Thank you.
Let's proceed then. Mr. Aaron, will you give us a brief status on this case since the last 341A hearing on April 18th?
Okay, the only thing of significance is the court authorized borrowing pursuant to Section 364 of the Code, and the fund should be available Friday or Monday. And those will all, of course, be recorded in the operating statements and interim reports.
This Friday or next Monday?
This Friday or next Monday.
And the amount?
And the $18,000, and the reason this Friday or next Monday is that in any consumer loan, federal law mandates that there be a right to rescind, and that 72-hour period must be observed before the funds can be delivered. And the lender is requiring that that time pass without the rescission.
I'd like to open the meeting to creditors who are present if they have any questions before the U.S. trustee proceeds with this questioning. Are there any questions by creditors? Mr. Cusano, I received your initial filing requirements and I have two questions. Are there any other savings accounts, checking accounts, or other types of financial accounts not previously listed on your schedules and statements of affairs and your statement of closing of accounts?
Yeah, other than the debtor in possession account, which
Other
is
than that, yeah.
That's
No.
right.
You have no other?
No.
Have you opened your debtor in possession account?
No. It's in the process of being opened. For the same reasons that we talked about, the bank requires $100.
I know on the schedule of assets and liabilities, it states that there's $300 at the date of the filing.
Right.
I had expected to find that out on the, or find that reflected on the DIC account. Can you account for that?
I don't know what you're talking about. On the date of the filing, it's $300. But the cash left on the date of the filing is $300. Probably did. Sure. It's a small amount of money. Yeah. The answer, as I understand it, the $300 on the day the petition was used for ordinary expenses such as food and I believe a utility bill or two. Okay, if it's not reflected, it should be, and you will see that it is.
Have you amended your statements as of today yet?
The statement of schedules?
Yes, schedule.
Not that I'm aware of. Ms. Patan was to amend those, and I don't believe she's accomplished that task yet.
So when do you intend to open your DIC account, Mr. Cusano?
Oh, probably very soon. Friday or Monday.
At the same time you get the...
As soon as the money's going to go right into the DIP account.
on your initial option report for builder savings, are there any post-petition payments not made on the builder savings secured debt on your home?
Bel-Air savings. That are going to be post-petition. This is the filing bankruptcy. We made a payment on the Bel-Air savings. Yes. No.
Are there any post-petition payments delinquent on the builder savings?
One. April's is delinquent and will be cured Friday or Monday.
Is that the case, Mr. Castano?
I believe it is. As soon as the funds, again, Friday or Monday, the funds will be delivered, and a day or two after that, the payment will be made.
Have they made any payments on pre-petition unsecured debt?
No.
On the operating report number 1.
No, you haven't, or no, you
No, I don't understand.
I mean, they haven't paid any since the filing. Creditors of the road. No. The answer is no.
On your real estate questionnaire, Mr. Castano, on item number 16, the disposition of the Chapter 11 case and the attempt to refinance the real property.
Where are you referring to?
Item 16. Debtor's intention as to disposition of the Chapter 11 case, sale, refinance, etc. Can you elaborate on that, Mr. Castano?
Let me respond as follows. I think the statement speaks for itself. I think that the plan would be to use either of those two sources of income.
I understand, but what steps have you made, Mr. Castano, in terms of refinancing of your property?
To this point, yeah. I mean, we talked to Mr. Castano has talked to a couple of banks about providing that refinancing.
So which banks have you talked to, Mr. Castano?
Mr. Lohr, in light of the, I'm sorry. I just want to call you Al. In light of our guests here, we'll be happy to respond with that information in writing.
That's fine, Mr. But there have been attempts, have there not been, Mr. Castano?
But that is not, so you're aware, that's not our first. The plan will provide an alternative. One would be, that would be the latter alternative. The former would be just a future income.
In regards to the future income aspect, Mr. Castano, and the plans of the organization, the future income that you're speaking of, future income from past product and past performance, or future income from future performances and future products?
Yeah, I saw future. But it's money with future income, future projects. It's not anything that you've done in the past. With old.
Future earnings on future projects.
Of course, except to the extent in the unlikely event there are any royalties that garnered from the old projects. That the likelihood is significant. The likelihood is de minimis, but just so the record's complete.
So the possibility that there may be some royalties from past.
Provided the record companies are recouped, yeah, that's a possibility. I mean, possibility exists. The possibility exists.
Item 16A and 16B of the case status questionnaire, reflecting on the time frame and the filing of the Chapter 11 plan. Mr. Castano, can you address that issue? At what progress are you at in terms of the Chapter 11 plan?
I think it'd be more appropriate for counsel to, since I'm
Counsel,
that'd be
please.
fine. In terms of the disclosure statement, it's in the draft. There's a that there is an outline of what the terms of the plan would provide for. The preparation of the necessary information to provide adequate information has not yet been collected and put into written form, of course. The first step before we even get to the filing of disclosure statement will be to set a bar date. And that bar, as I indicated, we anticipated that bar date to be sometime at the end of May, maybe June 1st at the latest. The application to obtain that bar date has been prepared by my associate, Ms. Patan. It'll be delivered to Judge Ashland on an ex parte basis with notice, of course, to the U.S. trustee, merely to set the bar date for that June 1st deadline, and then notice will be given to all creditors and interested parties.
We have spoke about a Mercedes-Benz which was purchased in 1988 and sold in 1989, previous the initial 341A hearing in Susano. Do you have any documentation regarding the lease contract and the dates of the transaction? Mr. Aaron,
We'll be happy to provide that.
Yeah, will you provide that in writing to this office?
What we'll do is...
Are you current on your Mercedes-Benz lease payments?
I believe so.
What monthly obligations do you have? Do you know?
I think we've already answered this. I think it's about 200.
Probably, yeah. I mean, it's around 200.
I'll turn it on. Regarding the years 1988 and 1989, just those years, Mr. Casano, your performances and your products that you produced during those years, in which bank account were the advances or any funds made from your performances and products put into? Do you remember?
No, I don't remember.
Well, we do have books and records on those.
It would be one of the bank. It would be one or more.
You have all the banks.
It would be one or more of all the bank accounts.
I'm just trying to ascertain which account.
I think if you look at the schedule, you can ascertain by process of elimination, because certain of the accounts are designated, for example, the retirement accounts.
Yes,
But if you eliminate those, I think, and if you eliminate those in the closed one, I think you're left with one or two accounts, if I'm not mistaken. But we will provide, I mean, if you want that information...
Let me proceed with the questioning, and then you can see what I'm trying to arrive at, Mr. Aaron.
Okay.
Mr. Casano, what types of advances were you advanced in 1988 and 1989, the type of advances?
No advances.
You advanced nothing in 1988 from any record company or label?
No, gee, I can't remember. I don't remember.
Mr. Aaron, I would ask that you respond to me in writing regarding the advances to your client that occurred in 1988 and 1989.
Were there any in 1989? No, there were no advances in 1989.
You would state that in your correspondence.
Okay.
Would I be distinguish the nature of those advances in 1988 and their amount?
Is there relevance to distinguishing the nature?
Well, from what I've been able to ascertain from prior discussions with you in terms of audit advances, publishing advances, full support advances, things like that, I just want to know if you've covered everything.
No, I understand that, but I don't know what the relevance of the type of advance as opposed to just the aggregate amount for the bank for Chapter 11 purposes.
Yeah,
I'll do the best I can. I'm not an expert in the area, but I'll do the best I can to see if we can determine which ones were for what purposes.
Thank you.
Sure.
Did you go on a tour in 1988, Mr. Casano?
Yes,
What was the purpose of that tour?
Earn a living?
Well, what was the purpose of the tour?
The purpose of the tour to promote my record.
Did you produce a record in 1988?
Yes.
What was the name of that record?
All systems go.
All Systems Go under?
Chrysalis Records.
The advances that were paid to you for your tour and I assume for your product, All Systems Go, were they paid directly to you?
The advances? Wait, can you rephrase that again, please? Or restate that for me, please?
The advances paid to you from any label, for especially from Chrysalis for this tour, were they paid directly to you? Produced the record and as an artist advance?
Yes, from the label, yes.
Directly to you, Vincent Cassano?
Yes.
What is Street Beat?
Either one.
Probably went to the loan out corporation. They probably went through the loan out corporation who actually handled the advance and paid for the service.
What is your relationship with Street Beat Music?
That's my company. That's one of my publishing companies.
For your purposes, Alvin, it's just like a loan out company. It's just like the loan out company.
Okay.
It doesn't do. For example, it does only Mr. Cusano's products.
Are there any other? You said that was one of your publishing companies. Do you have any others?
Vinnie Vincent Music was another.
And that was one we had discussed earlier in prior 341.
Right.
Correct, Councilman.
Right.
So with these loan out operations also made the disbursements on your accounts, Mr. Cassano?
I don't understand what
The loan out corporation paid the bills associated with the production of the records and the tours, or just the records.
It's really hard to say. It did for part of it, and
Let me ask you this. On the records that you have listed on your schedule of assets and liabilities, for the time that you were with Kiss, the new record with the Bangles, and the other 20 songs, the Christmas records, are all those under the Christmas Records logo?
all which one? All those that you named on the Christmas logo? No, absolutely not.
Okay. For the Bangles, your one song on the Bangles album, current album, which label is that?
CBS?
What source of revenue do you obtain from that one song on the on that album, the new album?
I don't know.
Have you even accounted? Have you got an accounting for it?
Have you received any royalties? But you failed to ask him the foundation question. The foundation question is, have you received any? And the answer is no.
Have you sued to find out if any royalties are due to you?
No.
Who handles the records? The company handles the accounting business. So verification is not Mr. Cusano's obligation to provide the accounting, but the accounting would normally be provided by the label. In this case, I think CBS would provide it. That's normally what happens.
Yes, but have you? Is it custom to just wait to see?
It's an annual, maybe an annual kind of thing.
Way of life.
I beg your
The
pardon?
way of life.
It's to live it.
Okay. On the Christmas album, you mentioned that you have 20 songs on the Christmas album. Do you write all 20 songs?
Yes.
Have you got an accounting from Christmas Records as to any royalties?
Yes, I believe not too long ago.
Who provides that accounting? Was that for 88 or 89?
I just really don't know. I don't really study them. I just
Receive them.
receive them. Put them in a file.
Your records with the band Kiss, what label are they with?
Polygon. Polygon.
of that performance on the product?
I did, and I do, but it's a year in the waiting, takes about a year, 3/4 of a year, something like that. When they come in, they come in.
And when was the last one?
I don't remember, to be honest with you.
Did you get one in 1989?
I don't remember. Honestly.
He doesn't remember.
No, I asked him if he got one in 1989, just to try and refresh his recollection. Okay.
Do you write any songs for any other persons with any other labels with royalties for a ride?
No.
Do you perform in any videos or produce any videos?
Yes.
You did? Can you describe the nature of the video?
Nature of the
Why
ride.
don't we give you put it in our written response. We'll just identify them and tell you who's in charge, who is the other party.
Okay.
The other party.
Counselor, on the letter I would look forward to receiving, will you note down the income and the disbursement from that income for that year that you're reviewing for? I'm particularly interested in 1988.
Oh, okay.
1988 counselor.
All right. Well, we'll see what again, I'm going to have to see what state the records are in, but I assume they're not. I assume they're probably they're okay, and I can just give you some kind of accounting.
Okay.
I have not reviewed the accounts, so I don't know what they look like.
I had asked your client regarding the books and records he had in possession at that time. He said had it all. So
You can have them all, but I have them all too. They're in a box under my desk, and there's and they're all my little receipts for the year for my tax purpose.
okay,
I mean, what state they're in is another question, Alvin.
okay. The next question regards I understand, Counsel. The statement of affairs, the property held by another, the $24,000 bond. Are you aware of the $24,000 bond in Massachusetts?
Oh yes, yeah, absolutely. I personally aware, yes.
Okay, are you aware of the $24,000 bond, Mr. Sana?
Yes.
Okay. Is that your fund, that $24,000 bond? Because as I recall,
Yes.
Mr. Ewing, during the question regarding the funding of the family organization, the $24,000 was assumed to be part of the estate and part of the corporate.
Subject to the bond.
Yeah. Is that $24,000 originally yours and put up as a bond for whatever purpose you had to do it for?
Not originally, but it is now. It's originally put up by the record company and Chrysalis, and now it's been charged back against Mr. As I understand it, they've charged it back. So part of what they're recouping is the amount of the bond.
Mr. Aaron, when could I expect receiving those items? Would next Friday be?
How about a week from this Friday, the 5th?
Next Friday.
Yeah, May 5th. That will probably. You know what, Alvin? If we can let's go to the next Monday, because I know I have 3 different things that have to be filed on the 5th. So let's say the 8th.
Are there any other questions from creditors or